What pundits get wrong about unlawful orders and what the law actually says. Senator Mark Kelly and several other veteran lawmakers put out a video telling service members they can refuse unlawful orders. And for weeks on end, everyone from TikTok personalities to cable news pundits were talking about something they know nothing about. Then it died down for a while until Admiral Halsey retired, and it was reported that he had actually disagreed with the administration about ongoing Venezuela operations. Now, I'm not here to talk about Venezuela. I have not been in the classified briefings. This is not an argument, a political argument about one side or another. But once he retired, you again saw talking heads yelling about their politically charged opinions. But this issue is not political. It is legal. And here's what I've seen the pundits get all wrong about it. You've got operators, senior NCOs, officers, and commanders, people who've dedicated their lives to service, being flooded with politically charged advice that has zero legal basis. And the stakes could not be higher. One wrong move based on bad intel could mean court-martial charges and the end of everything you've worked for. So, by the end of this video, you are going to understand the actual legal standard for refusing a military order. Not what someone on Reddit says, not what your buddy thinks, but what military judges actually use when deciding if you're going to prison or back to the mission and your life. And more importantly, you'll understand why most service members facing this situation are in way more danger than they actually realize when they don't understand the law. Because here's the thing, this is not hypothetical. Right now, there are operators and commanders being told to make decisions that could define the rest of their lives. And most of them do not know the law well enough to understand the risk they're actually in. The people giving orders and the people enforcing the consequences are often the same people. The asymmetry of that is brutal. Look, I've defended service members at every level, from junior enlisted to senior officers who face this exact conundrum. Some make the right call, some don't. And the difference comes down to one thing: whether they actually understood the legal standard before they made the decision. But this law is complex, so we're going to break it down into 7 points you need to understand. Refusing illegal orders are prosecuted under Article 90 of the Uniform Code of Military Justice for willfully disobeying a superior commissioned officer, or they're prosecuted under Article 92 of the UCMJ for failing to obey a lawful order. So let's get into it. Point number 1. Military orders are presumed lawful. That's not politics, that's the UCMJ. Your superior gives you an order. You think it's illegal, so you refuse. Now you just put the burden of proof on yourself, and most service members have no idea what that actually means. Let's be real, it does not matter who the commander-in-chief is, who the Secretary of Defense is, or who the Secretary of War is. The default legal position is this: if you are given an order by a superior, that order is presumed lawful. Now, something that also needs to be clear is this: that presumption has absolutely nothing to do with loyalty to a person or to loyalty to a particular party or even your personal political beliefs. This presumption is foundational military law that has been in place for decades. It applies whether you're enlisted or officer, whether it's peacetime or combat. What that means is if you're an E7 and an O3 gives you an order, the law assumes that order is legal unless you can prove it's not. If you're an O3 and an O5 gives you the order, the same thing happens. The presumption is always in favor of the order, unless the sole exception applies when that order is palpably illegal on its face. But that's the exception, and I'll explain what that means in detail later. And here's where it gets real brutal. The moment you refuse an order, you've taken on the burden of proving illegality of that order. Now, You're the one who has to convince a military judge that that order was unlawful. It's not your commander's job. It's not the prosecutor's job. You. That comes from United States versus New. Military appellate courts have repeatedly held that orders carry that presumption of legal validity, and the burden falls on the accused to rebut that presumption by clear and convincing evidence. So before you refuse an order because someone on social media told you it's illegal, you need to understand this. You're not just making a moral choice. You are making a legal bet with your entire career on the line. And the odds are not in your favor unless you know exactly what standard you have to meet. Point number 2, the Nuremberg defense doesn't work. I was just following orders will not save you. Here's where it gets weird. So the presumption is that an order is lawful, but service members cannot simply rely on being given an order. That's just as dangerous. Let me give you an example. You pull the trigger, a civilian dies. Your commander gave you the order. You think you're covered, but you're not, and here's why. Later, it turns out that that target was a non-combatant, or the strike otherwise violated the laws of war. You cannot just say, hey, my commander told me to do it. That's called the Nuremberg defense, and it does not work. It does not work in international law, and it does not work under the Uniform Code of Military Justice. You are personally responsible for your actions, even if you were following orders. Now, something that needs to be clear if it hasn't been, is that does not mean every operator is at risk for every strike. What it means is this. If the illegality of the order was apparent, if you knew or should have clearly known that the target was a civilian, that action violated the rules of engagement or the laws of war, you don't get to hide behind the chain of command. This is the nightmare scenario for most operators. You're told to act, and you find out the order was based on bad intel or political pressure. Now you're the one facing charges, and I was following orders is not going to save you. Because the US military was built on the rule of law, and because JAGs have held respected positions in our military for decades, courts martial for these kinds of cases are much more rare than for allegations of sexual assault or domestic violence or drug use. That's why operators need a lawyer who can understand military justice in the operational AOR, someone who has answered questions about real missions, someone who has an active security clearance and who can advise them in real time, not after the strike, not after the investigation, but when the order initially comes down. Because once you execute that order, once you pull that trigger, there's no taking it back. And if it turns out to be illegal, you're the one holding the bag. Point number 3, palpably illegal is an extreme legal standard, not your personal opinion. Look, you think an order is wrong. You think it's unethical. You might even think it's illegal. None of that matters unless that order is palpably illegal on its face. And here's what that actually means. The order has to be so illegal, so extreme, that it's clearly repugnant to a specific statute or the general law of the land. That's a quote from the case law. Clearly repugnant, not suspicious, not questionable, not something you have a bad feeling about. Here's the thing, your personal doubt whether an order is illegal does not give you the right to refuse it. The illegality has to be glaringly apparent, something that any reasonable service member would immediately recognize as criminal or manifestly beyond the scope of authority. Let me give you some examples. If your commander orders you to kill a non-combatant civilian, that is palpably illegal. If your commander orders you to steal property from a local national and says, look, it's fine, you're military, that's palpably illegal. But if your commander gives you an operational order that you think might violate some regulation or norm, that is not going to meet the standard. The case law on this is crystal clear. If you look at United States versus New, United States versus Kapla, United States versus Sosleski, all of these cases make clear that the order must be, quote, clearly repugnant to some specific statute, to the law or usage of military service, or to the general law of the land, end quote. The illegality must be manifest and not subject to reasonable doubt. Unfortunately, what I see happening in the media right now is people applying their personal moral compass, or worse, their political beliefs to this legal standard, and that's simply not how it works. Disobedience of a U.S. military order is justified only in extreme cases where illegality is not doubtful. If you have doubt, you do not have the legal defense unless then you can prove illegality of the order to the judge. So when you hear people talking about unlawful orders, ask yourself, is this order clearly repugnant to a specific statute? Would any reasonable service member immediately recognize this as criminal? Or am I just uncomfortable with the order? Because if it's the latter, you're about to make a decision that could destroy your life. Point number 4, the defense bears the burden, and it's clear and convincing evidence. You refuse an order. You get charged under Article 90 or Article 92 of the UCMJ. Now you're sitting in front of a military judge, and the prosecutor says the order was lawful. Your lawyer says, no, it wasn't. Who has to prove it? You do. And it's not even close. Most people think, well, look, I'm charged with disobeying a lawful order. That means the government has to prove the order was lawful, right? Wrong. Unless that order was patently illegal on its face, like we talked about earlier, you have to prove it was unlawful. And you have to do it by clear and convincing evidence. What is clear and convincing evidence? Clear and convincing evidence is just below beyond a reasonable doubt. It's the same standard used to terminate a parent's parental rights to a child. It is not a low bar. It's brutal. So now you're sitting there as an accused. Your lawyer is presenting your case, and you have to convince the military judge, not a jury, not a panel of officers or a panel of enlisted members, a military judge, that the order was illegal to that high standard. Meanwhile, the same people who gave you the order are actually the ones who referred you to court-martial in the first place. And that is the conundrum. The people who hold the keys to your court-martial are often the same people in the chain of command who either gave or endorsed that order. Unless the illegality is glaringly apparent, you are fighting an uphill battle with a 100-pound rock. And here's what makes this even harder. You're not just proving the order was questionable or poorly thought out or could have been done a different way. You're having to prove it was illegal under the UCMJ to a standard rarely applied in the UCMJ. That's what United States v. New requires. That's what every military judge is going to hold you to. Now, the good news is that if you meet that burden and overcome the presumption of legality, then the prosecution must prove legality beyond a reasonable doubt. But that only happens if you've made it all the way to getting the judge to clear and convincingly find the order was illegal. So if you were thinking about refusing an order, you better have a lawyer who knows how to meet that burden, because once you make that move, there is no going back. Point number 5, when orders cross the line: private purpose, abuse of authority, and rights violations. An order isn't just illegal because it feels wrong. It has to fall into one of these legal categories. And even then, you're going to need a lawyer who knows how to argue it. One category is serving a private purpose rather than a legitimate military need. For example, if your commander orders you to do something that benefits them personally, not the mission, not the unit, but their private interests, that is United States versus Parker, and that order is invalid. Let me give you an example. If your superior says, I need you to detail 5 people to come paint my house this weekend, that is an order that serves a private purpose. There is no legitimate military need. That order is illegal. Another category is orders that are excessively broad, arbitrary, or capricious. Orders that needlessly abridge your personal rights without a legitimate military justification. That comes from United States versus Mildebrandt, United States versus Green, and United States versus Smith. But here's the problem. These are legal arguments, not gut feelings. You don't just say, I think this was for his private benefit. You have to prove it. You have to show the military judge that there was no legitimate military purpose and that the order was designed to serve somebody else's personal agenda. And even if you're right, you still have to meet that clear and convincing evidence standard. At the end of the day, when you hear people talking about the legitimate purpose for a military order or the legitimate need for a military order, the reason they're doing that is to satisfy the case law in these cases. Because if an order is serving a private purpose, if it's excessively broad or arbitrary, that's where you can start building a legal defense. But you better have a lawyer who both understands operational law and the UCMJ, someone who can build a case before charges are even filed. Because once you're sitting in a courtroom, it is too late to figure out your theory of defense. Point number 6, the asymmetry, what senior officers can do versus what others can't. Look, a general officer or a flag officer who gets an order they think is illegal, they get to retire. An O3 who gets the same order and they refuse, they get court-martialed. Same order, 2 completely different outcomes. Here's why the system works differently depending on your rank and your time in service. Let's be real, if you're a senior officer, a general or a flag officer, someone with more than 20 years of military service, and you're given an order that you think is illegal, you have the most options. You can voice objections up the chain. And if you're told to execute that order anyway, if you're a flag or general officer, you can retire. Those are political positions. You can walk away and retire. That's it. That's because your position is presidentially appointed. But let's say for 06s and below, those options are more limited. First, for anybody who has over 20 years of service, you also have the potential option to retire. But retirement is not guaranteed because the service secretary decides whether you can retire in lieu of court-martial or not. And for those with less than 20 years of service, it's even worse. If you're an O3 or an O4 or an E7 with 12 to 15 years in service, you don't get that option. You can't just retire and walk away. If you refuse the order, you're potentially looking at an Article 90 or an Article 92 charge, and you could be going to court-martial. That's the asymmetry in this system. That's not just different spanks for different ranks. That difference in these particular cases is different spanks on steroids. General officers and flag officers have an exit ramp. Someone with more than 20 years has a decent chance at retiring, but it's not guaranteed. Junior officers and mid-career NCOs are trapped between their conscience and career. If they refuse, they risk losing everything: rank, retirement benefits, reputation, even their freedom. If they obey and the order turns out to be illegal, they could even still face charges. And here's the kicker: the people deciding whether to court-martial you are often the same people who gave or endorsed the order. So unless the illegality is glaringly obvious, you're betting your entire future on your ability to prove it in a military courtroom. That's what makes it so difficult for people on the ground, the people who are actually pulling the trigger, the people who are actually executing the orders. They are the ones with no clear exit. They're the ones who have to make a choice that could destroy their careers. And most of them don't know anybody that they can talk to about that particular issue. That's why junior officers and operators in this position need experienced military counsel immediately, not when charges are filed, but the moment they receive a potentially illegal order. And that's important whether they're considering refusing or following the order, because once you make the move, there's no taking it back. Point number 7, who decides if an order is illegal? It is not the president, it is not your commander, it's a military judge. Your commander says the order is legal. The president says the order is legal. You think it's illegal. Who's right? None of you. The only person whose opinion matters is the military judge hearing your case, and that is a cold, hard legal review. At the end of the day, It is not the commander-in-chief who decides if an order is lawful. It is not the Secretary of Defense or the Secretary of War. It's not your service secretary. It's not even your immediate commander, the one with boots on the ground. The legality of an order under the UCMJ is determined de novo by the military judge. De novo means the judge reviews the question fresh, from scratch, with no deference to what anyone else has said. The judge looks at the law, looks at the order, and makes the determination. Was this order lawful or not? Now, here's the problem. That determination happens after you've already been charged, after your career is on the line, after you've been dragged through an investigation and an Article 32 hearing. The judge isn't sitting next to you when the order comes down. The judge doesn't weigh in ahead of time. You have to make the call, and then you have to defend it later. And that's what makes this so difficult. You are making a decision in real time, under pressure, under operational circumstances where you often cannot consult with someone quickly. And the person who's going to judge whether you are right or wrong is a military judge you haven't met yet, applying legal standards most service members have never heard of. And that's why I'm sharing this information. Not because it's a hot button legal issue that everybody's talking about, but because as the dust has settled, it's important for people to truly understand the law. And that's why anybody who actually is facing one of these situations needs a lawyer who understands both sides of the courtroom. Someone who's prosecuted high visibility cases, someone who's defended high visibility cases, and someone who knows exactly how a military judge is going to analyze the facts and the law. Because once you refuse an order, the only thing standing between you and a conviction is how well your counsel can meet the burden of proof. Look, I get it. This is overwhelming. You're trying to do the right thing, and the system is stacked against you. That's why I built Veritas Military Law, to represent senior NCOs and officers who are facing the fight of their lives and need someone who's been in the trenches. If you or someone you know is dealing with a potentially illegal order, do not wait. Those first few hours matter. Sometimes that's all you have. Reach out to an experienced military lawyer and figure out the right move together, based on the law and based on your facts. Point number 8, what to do if you receive a potentially illegal order and why timing matters. You get an order, you think it's illegal. Most people panic, talk to their buddies, post on Reddit, and make a decision hastily that could destroy their career. Here's what you should do instead. First, understand this. The decision you make in those first immediate hours could define the rest of your career or the end of it. This is not the time to crowdsource advice from the algorithm or ask your buddy in another unit what he thinks. This is the time to talk to an experienced military defense lawyer who understands the UCMJ and how it applies to operational law. Here's the thing, most military lawyers don't have an active security clearance. If you're facing an order related to a classified operation, a legitimate target, a mission with operational security concerns, you cannot just talk to anyone. You need to talk to a lawyer with an active clearance who can actually hear the full story and give you legal advice without violating that classification. Second, you need someone who's been on both sides, someone who has prosecuted high-profile cases and knows exactly how the government is going to build the case against you if you refuse. Someone who's defended high-profile service members at courts-martial and knows what it takes to build a good defense. Unfortunately, most civilian lawyers have never been inside a military courtroom. They sit on their hands, file motions, and hope for the best. In these kinds of cases, you need an experienced military lawyer who can help you assess the risk before you make any decisions. Because here's the truth. Sometimes the right move is to obey the order and document everything, so that if it turns out to be illegal, you have evidence that you acted under distress or without knowledge. Sometimes the right move is to voice your objection up the chain and force them to put it in writing. And sometimes the right move is to refuse, but only if you and your team can beat the burden of proof in court. The worst thing you can do is act on emotion, act on politics, or act on bad advice from people who've never defended a high-profile court-martial. because once you make that move, regardless of what the move is, there is no taking it back. So here's what you need to remember. In the United States, a military order is presumed lawful, unless, of course, it is palpably illegal on its face. Palpably illegal on its face is a legal question, not your personal opinion. The Nuremberg defense does not work. You cannot say, I was just following orders. The burden of proof is on you to prove illegality by clear and convincing evidence. And the person deciding whether you were right or wrong is a military judge reviewing the case de novo after your career is already on the line. Remember, it is not what the president thinks or what his cabinet thinks when the order is given. It's what the military judge decides much later in time. Now, there's a whole other side to this that most people don't understand. What happens at trial is not all about what happens at trial. In another video, I'm going to walk you through the 4-pillar defense framework we use to move the ball forward before charges are preferred. Because if you're waiting until trial to fight, you've already lost. Now that you understand what palpably illegal actually means and why most service members don't really understand how the UCMJ considers orders and whether they are illegal or legal, you need to know how to fight back when you're facing an Article 90 or Article 92 charge. In another video, I'll show you exactly how to take control of your defense before the system buries you.